Welcome to the LLB Guide, where knowledge meets justice. Together, let's explore the world of law with clarity and confidence.
Question: What defenses are available to an employer for exemption from liabilities to pay compensation under the Workmen's Compensation Act, 1923? Introduction: In industrial and labor laws, the social welfare of employees is highly prioritized. The Workmen's Compensation Act, 1923, outlines a statutory framework where employers are strictly liable to compensate workers for injuries sustained in the workplace. However, this liability is not absolute. The law provides specific defenses or exceptions where an employer is legally exempted from this obligation. Definition and meaning: The liability of an employer to pay compensation under the Act arises when a worker suffers personal injury due to an accident that happens, out of and in the course of employment. An employer's defenses refer to the legal grounds or statutory exceptions provided under Section 3(1) of the Act, which allow an employer to escape the payment of compensation. These exemptions ensure that employers are not unfairly penalized when an employee's own deliberate recklessness or clear disobedience is the root cause of the accident. Available defenses for exemption: Under the Proviso to Section 3(1) of the Act, an employer is exempted from liability in specific circumstances, generally involving misconduct by the employee. 1. Short-term disablement: Under 3 days, the employer is not liable if the injury does not result in total or partial disablement lasting more than 3 consecutive days. 2. Influence of drink or drugs: If the accident is directly caused by the employee being under the influence of alcohol or drugs, the employer is exempted. 3. Willful disobedience of safety rules: The employer is exempt if the injury is caused by the worker's intentional disobedience of an express safety order or rule. The employer must prove the rule was clearly communicated and intended for safety. And 4. Willful disregard of safety devices: The employer is not liable if the injury results from the intentional removal or disregard of a safety guard or device provided for the worker's protection. Examples in case laws: Examples include a worker intentionally ignoring safety goggles or removing a machine guard, which constitutes willful disobedience. Mere negligence does not trigger this defense. In Bhurangya Coal Company Limited versus Sahabuddin, it was held that only willful disobedience excuses the employer, not simple negligence. Furthermore, in Mackinnon and Company Private Limited versus Ibrahim Mamd Ishaq, the court emphasized the need for a causal link between the accident and employment duties. Conclusion: While the Act protects workers, it offers fair exemptions for employers under Section 3(1). These defenses apply when workers willfully ignore safety protocols or are intoxicated. However, in cases of fatal accidents or permanent total disablement, these defenses are generally not available, and compensation is required regardless of the worker's conduct.
Keep learning, keep growing with the LLB Guide. Don't forget to subscribe and explore more lessons in law.